But you see that we're constantly coming back to the topic of reform of the court. And the reform of the court means speeding up the procedure to make sure that the court is efficient. Because that is, again, a rather fundamental issue. The more you allow the court to work, the more access you allow to the court, the better the court works, the more difficult it is for the court to work. Because the more open you are, the more cases you invite, the more access to justice you allow, the harder it will be for the court really to work. So there is a balance to be struck between the court being effective, efficient, and at the same time being at your disposal in a reasonable way. One other way that the court has responded to is by saying we are looking at cases in priority. Again, this is a little tricky. Yeah? Whose priority? Well, the court seems to apply objective criteria by saying cases that are first of all serious and secondly manageable. Meaning, first of all, cases that involve urgent applications where really life is at stake, children are at stake, or things like that. Such systemic problems, structural deficits, violent judgment issues, we'll come to the violent judgment in a moment, and things like that. Thirdly, even more problematic, the real important rights, which the court seems to identify as these ones. So if you think for your child the right to education is the most important right at this given moment in time, you'll have to convince the court that your case should have priority, because the court will say, not in the list. Physical integrity is more important than access to education. It depends, I would say. But there's a court that says that we have that discretion, not for the fun of it, but because we want to speed up the procedure. And those that work, that are neither repetitive or that are not inadmissible, so those that actually are skilled. Is that acceptable for a human rights court to do that? In pragmatic terms, why not? If you look at it from the indivisibility of human rights, one could have a theoretical debate about this, I would say, at the very least. And judging from your faces, you would like to have that theoretical debate. Court can do two final things which are important sometimes. One is interim measures.